Right. Now, I think I like the fact that we can interact freely on this uh, with regard to this topic. You all are architects, and I think you all are integral to the whole planning process because you all participate very actively. You know, you have to put up building plans and so on and so forth. And you have to, of course, advise your client as to what is required and put up the necessary documentation and the fees and so on and so forth. So I think what I'll do is this, what my proposal is this, although I got some slides, I also set up some kind of a chart for you to look at, just to track through that whole planning process. Because what's happened is, on the 20th of January this year, the federal court has come up with a very comprehensive judgment, which has reviewed the entire planning process and placed it in the context of all relevant laws that can interact with the planning law. For example, the first, of course, is the Town and Country Planning Act, which is the code for planning. And then they've also introduced the, there's also the Land Conservation Act, all right, which you have to take into account. Then there's also the National Land Code, because planning is always in relation to land. And they have given a widest interpretation and integrated all these laws together to say now what is the proper planning process that must be adhered to. And they did it in the context of the approval given by the Majlis Perbandaran Pulau Pinang. Is it MPPP or MBPP? B. B, okay. Okay. So MBPP. Now, so one of the first things I want to do is to look at what the MBPP did. All right. Now, before that, let me tell you exactly how this case proceeded. First is that there was this Sunway, you know, it's one of the subsidiaries. They call it Sunway something. All right. It owned a large piece of land in Sungai Ara, and it put in a planning approval for development of condominiums, bungalows, and other structures over some 80 plus acres of that land. Now, the significant thing about this case is that about more than 40%, about 43% of the land was on hill slope land. And there are certain regulations which I'll come to in a while under the structure plan dealing with building on hill slope land. And they went through the whole process. They went through the EIA and geotechnical and everything they did. All right. Then the MBPP approved the plan. And the residents in the area objected, raised objection, because if you look at the one of the main persons who objected to it is called Sunrise Condominium. If you go there, you'll see Sunrise Condominium is there. And then there is a steep hill that goes up, and that's where the development was going to take place. So they were obviously quite concerned of the fact that, you know, if any calamity were to happen, they would be the first recipients or the first sufferers of this, any problems that might arise as a result of the construction. So they objected, but the MBPP considered their objections and still gave the planning permission. Then the residents are entitled under the law. The law is the Town and Country Planning Act. Under the law, they are entitled to appeal to the State Planning Appeal Board. So they appealed. A panel of 3 judges, as it were. One was a lawyer, and 2, I think, like assessors, lay people selected. They ruled that the planning approval was wrongly given. We will go into the reasons. All right. And then the Sunway and the state authorities were unhappy with that decision. So what they did is then you can file for what we call in law, judicial review. Judicial review means, anybody who is unhappy with any decision of a public authority, you can then file an application to review that decision by the judiciary. So it's called judicial review. So it's very popular, a way of contesting any decision made by any public authority. All right. So they filed a judicial review at the High Court in Penang. And the judge, after hearing submissions and so on and so forth, ruled that the appeal board was wrong. Appeal board was wrong to say the planning permission is to be quashed. He says no planning permission was properly given. All right. And then at that stage, I was not involved. And then we appealed to the Court of Appeal. We are entitled to do that. So Court of Appeal confirmed the decision. They took a long time to give the decision, more than 2 years. Then they came up and said, yes, everything that the High Court said is correct. The MBPP followed the procedure correctly, and therefore the planning permission should be is properly in place, right? And then we had two decisions against us, the High Court and the Court of Appeal. Now then, there is always a recourse to go to the highest court, which is the federal court. But before you go to the federal court, you must get leave. It's not automatic. It's only for certain important issues of either novel issues or important issues in respect of which it is important for the federal court, the highest court, to lay down some guidelines. So we got the leave, and then the case went up to the federal court, and then we spent, I think, a couple of days arguing. Normally, federal court is quite fast, one morning or one whole day, but this went over a few days. And then the decision came in January, as I said, of this year. And this is an extremely important, it's in fact a landmark decision, all right, with regard to planning law, because it has reviewed the entire planning process as to what the local planning authority must do when there is an application for planning permission. So in that sense, I think it's of importance to all those professionals like you all, especially who are involved in advising as well as putting forward documentation to support a planning permission application. All right, now, so that was the court proceedings that went on. Now, I think one of the best ways to see, because of this whole idea is, we're going to have an informal discussion to see what is right, what is wrong, what is supposed to be done, what's not proper to be done in the context of what has been now established by this case, the Sunrise condominium against Sunway construction and so on, right? So now the thing is, actually, let's look at what the best way to know right or wrong is to see what was the practice of the MBPP and the State Planning Committee in terms of planning permission approval, right? Then just as a sidebar, a few months after that came another decision which we had also brought. This was a decision, so this is under the Town and Country Planning Act. Town and Country Planning Act is throughout the whole Peninsular Malaysia, right? But for federal territory, we have the Kuala Lumpur Planning Act. It's separate, all right? More or less identical terms, except in one or two areas of difference. So that's also an important decision that I might just touch on in the discussion. Because in that case, that was a case, I don't know whether you heard of Molten, Molten, the Pavilion guys. They, one of their subsidiaries had got planning permission to build on half of Taman Rimba Kera. That's in Taman Tun Dr. as well, for those who are familiar. And then they got planning permission to go into a joint venture with CSR arm of Dewan Bandaraya Kuala Lumpur. So we also had challenged that, all right? And there also then, right, the federal court decided that the planning permission, the whole process, and the way in which it was done was entirely wrong. So actually, these two cases, federal court cases, are cases that have comprehensively set out exactly what is required in that entire planning process, right? Now, so first is, I think, first thing to do is exactly what the MBPP did, which they firmly believe, right? And they argued very strongly throughout, and they won on 2 rounds, we won in the final, but they won in the 2 rounds. What they firmly believe is the right process, which they have been following all this while. And they said that this is the right process. They defended it very strongly. They engaged, top lawyers in the country to maintain that position that what MBPP has been doing all this while is the way, the process to follow in respect of planning approvals, planning permission, and all this, right? Now, just to give you a broad, the Town and Country Planning Act is a very comprehensive code that deals with all planning things. 2 aspects. One is development planning, which means the first part is, of course, the development of structure plans and so on and so forth. So that is development planning to set the pace for which in the future all development is to be guided by. And that's a very comprehensive process, which needs to be taken into account because it is critical to engage stakeholders, because that is the habitat and the basis upon which they make decisions where to locate industry, where to locate themselves, where to buy houses, and so on and so forth, right? So it is actually that process has been now declared to be almost pristine because it is part of a democratic efforts, all right? Public participation is a critical factor in this because the authorities can only do it. It is a contract. The authorities have said now, it is actually a contract between the authorities and the people involved in the state or the local locality and so on and so forth. And it is the process by which it is to be arrived at is very sacred almost and has to be adhered to, right? And it involves issues of transparency, accountability, and democracy, and so on and so forth. So that is one part. One part is that development plan. And then the second part is control, planning control. So planning control comes in because everyone who wants to get permission for a project, for example, they must then plan. They must go to the planning authorities. So this case mainly touches a bit on development planning, all right, that process, but mainly with regard to planning control, how planning permission is to be the whole process for securing planning permission. So let's look at what the planning permission as far as MBPP and the state planning committee, which means the state government, felt is the right thing to do, right? Which they have been following all the while. So if you look at, all right. Okay, now there is in place, I think maybe we can look at the chart that I put up also. All right, there is in place, I think you all got one in color. All right, so as far as application for planning permission is concerned, so it goes to the local planning authority, which is the MBPP, and then it has to be considered in the context primarily of the Town and Country Planning Act, TCPA, all right, which was has been adopted in Penang or inserted in Penang in 1983, and also other laws that are relevant. For example, the Land Conservation Act. All right, Land Conservation Act. If land is declared as hill land, then you can't disturb it at all unless it's excised from that Land Conservation Act, and also the National Land Code, for example. And then you have in Penang, you have the structure plan. This is part of the, as I told you, the first part is development plan. So you put in place the structure plan, the local plan, and so on. And that is going to guide development for the next X number of years. This is the Penang Structure Plan 2020, right? Promulgated in 2007. And then, so you have the structure plan, and then you go on to then before planning permission can be considered, you have to go to the EIA. Just skip the next one. You have to go to the EIA, SIA, and so on and so forth. All right. And then the EIA and so on, traffic impact assessment, everything. And then it goes to technical approvals. All right. Then before that, I don't know how you decision, but not actually before the decision itself. Wrong, the arrow has been drawn wrongly. Before the decision itself, in respect of, then it must, before the decision, it must go back to the SPC, state planning. All right, very final decision. And in certain cases, right, one of them is sensitive, environmentally sensitive areas, one of which is hill slope land involving a certain gradient and height. All right, so this case is relevant because if it is 250 feet above sea level and the gradient is 25 degrees or more, then it is considered environmentally sensitive. And so it has, the SPC then must refer it, goes right to the top, to the NPPC. NPPC is the National Physical Planning Council, which came in by way of an amendment in 2001 or something like that, right? Because the federal wanted to integrate all planning development because there were some calamities that were happening, landslide, and then federal government was also involved, and they also wanted to have a planning process that is harmonized throughout Peninsular Malaysia. So they amended the TCPA to say, in respect of certain kinds of lands, planning commission, you must go to the National Physical Planning Council, NPPC. And it's high-powered, chaired by the Prime Minister and assisted by the Deputy Prime Minister and relevant agency heads, as well as the chief ministers and of every state in the country. So it's very, very powerful. And they say it's advisory in nature, but advisory, when you say a body with the Prime Minister and all these high-powered people to give you advice, you better listen to the advice. So it's more than just advisory as we think of the normal word advisory. So then it goes to the MPPC, comes back to the SPC, and then only a decision can be made after considering all these factors. Okay. So that is how the planning process is. So let's see how the MDPP has been doing it all this while, which they maintain is correct, as exemplified by this particular, the facts of this particular case itself. Now, in fact, this case is concerned 40. We call it Sunway had applied for planning permission to build all these structures and condominium on some 80 plus hectares, I think, of land, of which 43% as I said, was hill slope land of this nature, of the sensitive nature, with the 250 feet above sea level and 25 degrees, right? Now, so let's see how this planning permission was given and maintain that it's correct. So that was, all right, structure plan had set out. Now, structure plan had absolute prohibition on hill slope development, all right, of this nature, absolute prohibition. But it also made a provision, because there were planning permissions given beforehand and so on and so forth, that where permission was already given, they had, what do you do? Because, once permission has been given before the structure plan has come into place, then you cannot take away people's rights, you see, because people have bought land and developed the land, or the land, or the then remaining. So they had to have some provision made for projects of that kind, which they call special. And then in this case, the Sunway said that they had grade A land. The highest level of and so that was the context which the structure structure, so the structure plan is happening. Then there was no local plan. Usually what happens is once the structure plan, there was and we know structure plan is possible. And then structure plan, local plan is then detailed. It has to be set in good faith, right? Now, the point is, as far as MVP, percentage. But what they did, they had what was called plan data, because I won't go into the details, but for the interim period, because they didn't have local plans long time, they will have had a plan data. It's not gone through that normal process for development plan. Local plan also go through that thing. Right. This plan data was, initiated by a civil servant. I think it was a state director, and he went and put in his rules and so on and so forth as to what should or should not be done. All right, and the state authority was using the plan data as the basis upon which projects are going to be considered. All right, so that was a very critical factor in their argument to say that, look, we don't have local plan, but so what? We got plan data. We already decided on plan data. So what's the issue? But was it consistent with the structure plan? They said no, structure plan, they argued. No, structure plan is just broad plan only, just policy. You don't have to follow it. Of course, it's there, but you don't have to, you don't have to slavishly follow it. Now, structure plan was already gazetted after going through a process, public participation, stakeholder consultation and all that. All right. So they said no need to follow the structure plan. So what happened then? They want to use the plan data, but they had this, the state director or the state planning committee, in other words, state government felt that, got some, not selaras, not harmonized, because they got people got grade A land and some people already got approval beforehand. And then how do we deal with all these kind of issues? So then what they did was they established their own guidelines to follow. So don't forget the structure plan, no local plan. Then they set up their own guidelines. So it is outside of that whole code by which you are going to do your planning, the provisions for planning. The provision for planning, the development plan, and you must follow it, and so on and so forth. So then the state director said, oh, this, so many issues, problematic issues, how do we deal with the people who come with grade A land? How do we deal with last time projects already approved and all that? So they said, never mind, no issue, no problem with regard to that. We know how to solve the problem. The state planning committee and the state government said, we put our own guidelines lah. And then the guidelines can be used as the basis for dealing with this kind of difficult situation or complex situation. Okay, so they then created all this special project guideline, and these were the guidelines that they used to approve the Sunway project. And the basis was suddenly got before. But it's okay, huh? All right. So these are the guidelines that they used to approve the Sunway development project. And one of the guidelines also said that anything that has been approved as a project under the plan data. So any project or any land that is under the plan data that can be approved, all right, or is designated for housing, you can use. So blanket, in other words, you can sidestep that absolute prohibition in the structure plan, all right, absolute prohibition in the structure plan by saying that, my land under the plan DASA can be used for housing. So complete ignoring of the structure plan. But the state government, through these guidelines, how were they established? Not through the normal process, public participation and all, because they are also part of the development plan. But they said that we are entitled to deal with this through these guidelines that we have. And these were, how were they formulated? State director put forward the guidelines, then came up to the state planning committee. State planning committee discussed it and put it in the minutes. So these guidelines are actually nothing more than minutes recorded by someone. And then this is the basis upon which the MBPP was using all this while. So two problems there. One is using a process outside of the normal planning process control, the development. And secondly, they are establishing their own to bypass or to qualify a structure plan which has gone through the process. And thirdly, they are using a plan DASA, which is actually an interim zone sort of a approval process. They're using that as a basis to approve, right? So you can see where MBPP has been, what MBPP has been doing all these years and justifying it, right? Now, in the court, and the court, high court, because remember it went to the first to the local authority, then appeal board, then high court, court of appeal, then federal court. So we're doing the FC means federal court. So now, when they argued and were arguing all the while, and the court accepted, the high court accepted. They said, actually, we don't have a local plan, but it's okay. Our plan DASA is very detailed. Talk about density, talk about this and this. So what's the problem? Why are you raising this issue that we cannot rely on the plan DASA? In fact, plan DASA is a local plan. And the High Court bought that argument and put it forward and put it in its decision. So no need a local plan. Plan DASA equals to local plan. Right? So this is how MDPP was operating and the State Planning Committee was operating. Right? And then the SPC then said, okay, we now got guidelines already. You can do what you want. You got guidelines. SPC, like in my chart I showed you before a decision is made, you must go back to SPC, you see. SPC said, no need lah, because it is too troublesome. You want, like this government. That's not the politics, right? No, but this government to development, Some people say called development action party and so on, but that's critics. But the fact is that they said, this we don't want all this cut out this red tape business, So straight away just told the MBPP, you just follow a guideline, no need to come back to us. The moment you follow the guideline, you can approve. Don't waste time. Right? And no need to come back to us. So which means if you no need to come back to us, if you see from my chart, right, must come back to you, and it is environmentally sensitive, must go to NPPC. SPC only can do it. Go to NPPC and then come back and so on and so forth and get the advice. So that whole process, the state government, SPC said no need, they cut that out for efficiency and for facilitating approvals, giving approvals for the development of the state. So they then gave a direction. They are entitled to give direction, right? The planning commission, planning authorities must approve. So they said we are entitled to give direction. We direct, go ahead and do it. So, so what happened then? If you look at the second last, the third last, the light. Yeah, if you go back here, relied exclusively on the direction of the, so here they went under the zoning plan data, right? They created guidelines. Then they said, yes, we can consider Sunway's approval process through the guidelines. And then that will be based on Plan Dasar. So this is grade A land, which under the Plan Dasar has got some designation for housing. Right, so automatically we do housing. And then SPC said, okay, we direct you to rely exclusively, don't need to come back to us. So what happened is, therefore, if you look at it, actually the planning approval process has 3 tiers. It has local planning authority, it has SPC and federal NPPC. So there are 3 tiers. So what they did was they cut out 2 tiers. SPC said no need to come back to us, only 1 tier. And this is what they have been doing. The MBPP, prior to this decision, this is what they have been doing and maintaining that they are right in doing it, right? And of course, once you cut out the SPC, then the whole NPPC process and all is undermined. You don't need to go back to NPPC with regard to environmentally sensitive land, right? So they when we challenge, when we argue that they had to follow the whole process in the chart there, all right? They argue that no, if you want to challenge SPC, you are filing it, you are what do you call it? Challenging decision of MBPP. So they rely on a technicality to say, since you only are bringing in action against the MBPP, now don't come and question SPC and MPPC, they did or did not refer. This is outside your right to, in a court of law, there's some lawyers here, right? This is outside your right to do that. If you wanted to challenge the SPC, bring something else against SPC for payment. You cannot just bring it now and bring it as a fault of the MBPP. So MBPP were just confined. Did they do the right thing? Did they go through EIA, geotechnical, this? Did they act under the direction of the SPC, right? And there were guidelines by the state authority. They followed that. So what's the problem? So that is what they had maintained and succeeded in maintaining at all levels of the thing until it came to the federal court. So now in the federal court, next slide. Okay. So federal court, it came to that. So did they do right or wrong? Because this will then determine how the planning process must actually be accomplished. And permission sought on the basis of the correct planning process. All right. Now the first thing is, all right, the Penang structure plan. The structure plan had already said absolute prohibition in certain situations for special projects. So the first thing is you have to follow the structure plan. Slavishly, they said, because there was a previous decision that say don't follow slavishly, you can change it around. I mean, there are provisions for making adjustments to approval of projects, you know, that you can, there are processes, all right? But they basically defied the structure plan and said we don't have to follow the structure plan blindly or slavishly. But the federal court said that's wrong. You must follow it blindly, slavishly, they said. Because why? Because it's gazetted already. It's gone through a whole process and gazetted. So you have to rely on. So the first lesson, as far as the federal court decision is concerned, is the first step is to look very carefully at the structure plan to see what the structure plan allows or does not allow. And under the Town and Country Planning Act, under section 22(4), 22 subsection 4, you cannot approve any development if it violates the structure plan. So that's the first thing that has got to be considered. Structure plan. And in fact, this also for the Taman Rimba Kiara case in KL, although there's no such provision which says that you must follow the structure plan when considering development. There also the court held, yes, you have to follow it. And if it violates it, and there the structure plan had said that the Taman Rimba Kiara Park was shown in the structure plan as a park. All right. Okay. Now, the second point that is important to remember is that any guidelines that Oh, online. I see. Or make it closer. Okay. But closer got echo. Lah. Maybe do some karaoke singing or something. So what do you call it? Now the if you want to change, you see what the federal court said is you by bringing the guideline through a state director and minutes of SPC meeting are actually changing the whole development planning process because development plans, structure plan has gone through all the process. And in the Town and Country Planning Act, it says that if you want to change or amend or vary any part of the structure plan, you must go through the whole process again. Public participation. Public participation doesn't just mean residents and so on, also means other stakeholders, industry players and so on and so forth. So you cannot, through guidelines, undermine the structure plan, which has gone through a process of public participation. So public participation is key. So you cannot abridge it through guidelines and then MBPP just simply follows what is actually outside of that whole development plan process. All right, so that is the second important point that was made. All right, so here I put in here rule by decree and fiat and undermine the whole process. So what state planning committee was doing was, almost by decree, I decide this, I know what I'm doing, I direct, LPA to do it. You in fact even undermine the autonomy of the local planning authority. Right, local planning authority, mayor, councillors, all are appointed by the appointed under the Local Government Act. They have an autonomous existence. But in here, what was happening is the state planning committee was Aku Raja lah. They were controlling everything, directing what is to be done, what is not to be done. Now, there are provisions in the local planning authority, in the Town and Country Planning Act, where they can give directions and the local planning authority must abide by those directions. So they were relying on that provision. But the court said, and we pointed this out, under the Town and Country Planning Act, you can give directions, right? Because that's necessary. But directions must be consistent with the provisions of the Town and Country Planning Act. So you cannot undermine that process because otherwise you rule by decree. You see, dictatorship, we just said, you follow this, you follow that. Then you might as well must just have one stop authority under the chief minister and the exco or whoever is the subcommittee of the exco, right? Or only the state planning committee. No need for anything else. So you can't, what do you call it? And the very important thing is you cannot also undermine the whole process. That, in other words, the law must be adhered to. Now, okay, so basically that was what. Now the thing is, as far as the Sunway was concerned, they said, but first is, and then they ruled the plan DASA has no status under the Town and Country Planning Act. Town and Country Plan is structure plan. After that, you go local plan. You want to change anything, must go through the whole process. Public participation is key because this is structure plan is a forward-looking plan. All right, it marks the future development by which the state is going to be guided and planning authorities have to be guided. So you can't have they said the plan DASA is illegal as in the planning process, approval process. It's illegal. The state authority argued very strenuously, all right, that no, all the while we've been doing, plan DASA, and plan DASA look is very detailed. And if you don't follow plan DASA, means the whole development in Penang is going to come to an abrupt halt. We can't give any approvals already. Court said no. Court said the Town and Country Planning Act is there, and you should put in place a local plan, right? And you have yourself to blame in a way, I mean, that's impliedly said. So don't, and then you cannot use that as a basis to jump out of the whole code, planning code, and then try to justify it. Because then you see what was happening in MBPP, what we argued quite strongly, is that the state was controlling everything. The state exco is controlling everything. I want this to be done. I want increase of density. I want this. I want that. And then the local planning authority was more or less abiding by that kind of a direction, and they did it through directives. So the other thing that the federal court said is, you want to have directives, you can, but it must be, and they use wordings that exist in the act itself, it must be consistent with the provisions of this law. This is the town of Penang. Now, the other thing then they raise is that which the planning authorities have been agreeing to. They said he got clean title. What? He got grade A title. Under National Land Code, there is no prohibition for him to apply for developing the land in any which way he wants. All right, because he got no halangan, what do you call it, prohibition of any kind in his title. So normally we also look at title because of course we respect title. But the court said no, that where title is one thing, but if you want to develop that land under that title, then there is a process, and that process must be adhered to. And you cannot say, I got commercial, what do you call it? I got a commercial title. I got a title which allows me to develop in any which way I want. So that also the federal court has ruled cannot be done. Where there is a clash between the National Land Code, not necessarily a clash, but where there is you have a title under National Land Code, it is, if you want to develop that land, you still must go through the planning process, and planning process trumps your title, supersedes your title. So this whole argument on grade A title was also not accepted. All right. Then this was described as on the title itself somewhere. It is also subject to the Land Conservation Act. Now, as architects and professionals, you know that that once there's an endorsement, it has to be looked at. And what does the Land Conservation Act say? Land Conservation Act says you can't even cut a shrub without permission on hill land. What is described as hill land, and this was hill land. All right, you can't even do that. So after they had agreed in principle to give permission to Sunway, the authorities, the MBPP, suddenly realized, oh dear, because there's the residents, Penang NGOs and all, very, supremely active. I mean it in a good way, right? So then they realized, Alama, we already never gave this hill land, yeah, correct, So then they said, never mind, because the Land Conservation Act says, unless cut out on that, you must abide by the concept of hill and go by the land conservation. So they then said, what do you call it? They then said that then they asked Sunway. They said, hey, this one you better get it excised. So after agreeing to approve it, right? When there is in place this law which says you cannot deal with the approval process, or you cannot, give any permission even to cut a shrub, let alone have a project or condominiums and structures. They then advise, I suppose, right, the Sunway to apply to excise it. So this is after the event. It is normally not in good faith, So after the event, they allowed it to be excised, and they allowed it to be excised. And in the court, they argued, they said, yeah, no, it's not inland. We have complied with the Land Conservation Act, because Land Conservation Act only applies if it is not excised, and will be excised. Right? And then what do you call we had, so what we can therefore, and there are so many other aspects which we can discuss after this, but essentially, therefore, the process that was being adhered to by the MBPP all this while was not autonomous, was not independent, was subject to directions by the State Planning Committee. State Planning Committee itself was violating the law, and that is very important, because when they argued that, look, just look at the, what are you questioning, which is what we were doing. Because as I said, you can file an action in court to say that what you did was wrong. So we were saying what the planning permission given by NBPP was wrong. So they say you limit to that. Why are you going outside here and there, NPPC, this and that, right? So they argue very strongly on that we cannot go outside of it. When you go outside of it, then you bring an action against SPC. And say they were wrong. And this is very important. Court said no. When you're looking at planning permission and questioning planning permission, it means the entire process from beginning to end. You have to look, the court will look at the entire process because your planning permission is based on on abiding by the law which exists from A to Z, you see? So you are at the Z state or Z state. So we are entitled, the court said, to look at the whole process to see whether it is right or wrong, and not just. And so the first fault, they said, is with the SPC. How can the SPC give directions, right, when it has to come back to it to make consider the whole approval process? And the only reason that we can think of is because actually SPC was running the whole show in the local planning authority, MBPP. So that's why they no need to come back. We already directed you, you follow, right? But technically or properly, if the MBPP is supposed to be autonomous, so they give permission, then they have to refer back to SPC, right? So SPC said no need, all right? But what that also meant, so SPC, that tier, I told you 3 tiers are preserved under the law. One is the local planning authority, MBPP, then the SPC, and then the NPPC, right? So by cutting out that, you have demolished one tier that is mandatory under the local planning law, all right, under the town and country planning law. And more importantly, therefore, you will not refer, you just cut that out and said you go ahead. But that means that whole law part, which requires the SPC to refer this to NPPC in respect of environmentally sensitive areas, is sabotage. It's undermined completely because you're saying that we can give a direction to follow the guidelines that we have constructed outside of the Town and Country Planning Act. So the whole thing, as far as the federal court is concerned, was messed up. And this mess is what the federal court finally cleared and has cleared. If you have the time to read, it's quite a long judgment, has cleared up. And there are important other provisions, that other concepts, because they say, therefore, actually, the state authority, right, and the local planning authority, which is the MBPP, has undermined that whole planning efforts that has been so carefully constructed under the Town and Country Planning Act. What it has done is, first, in regard to, it feels it can amend the structure plan by state director giving a guideline, right? So you have undermined that process. And that is part of the democratic process, they say. Because democracy requires participation of those who are going to be affected by any development. All right. So you have you have undermined that particular process. And if you look at the Town and Country Planning Act and the kind of considerations, there are also environmental considerations. Sustainability, environmental consideration. We hear these words all the time, but people just say, must be done sustainably, without realizing that there is content to the meaning of sustainability in environment, right? Which means it must be able to withstand projection into the generations of our children and so on and so forth. We must be sustainable in that context when you consider. So they said even environmental and sustainable concepts were thereby undermined by the state planning committee, the state government itself. So the whole concept of an arrangement, you see, because the MBPP is actually in the service of the people that are in the state, governed by a law, which is a structure plan, a local plan, and it has to be done in a way that accords with the interest of the purpose. So basically, the message that the federal court finally gave is that you have undermined every integral and fundamental element that lies in respect of the development of the promulgation of the town and country planning Act and how it has to be played out in the development process, right? Which is part of 3, and the planning commission process, which is part of that dismal note I end for the moment. Thank you very much. Up to you. You can continue now. Yeah. I mean, we can, because it's I've sort of reduced everything to some of the essentials, huh? There's a lot more that arises in the context of the decision itself. I've not gone into. Yes, please. Yes, completely. And they argued, and the court accepted at the high court level, that actually no need for local plan. This is a local plan, which is, a very serious ruling to make by the judge, high court judge. Why? Because it's almost sacrosanct, that the whole development is designed to have a structure plan which raises broad areas, all right, and shows the zoning and use of lands, park and industrial and residential and all. And based on that, once it's gazetted, you have to then develop a local plan almost simultaneously or almost immediately. So what the state government did is no need. So this is very undemocratic, you see, right? Why? Because then you bypass the whole process and then you rule, you see, SPC decides everything based on their state directors company, the interim, it's called an interim zoning planning something done by a civil servant. So how can a civil servant, draw up what the local plan requires, the TCPA requires a whole process to develop a local plan. Like now I think now Penang is developing a local plan gun. Yeah, so is KL developing a local plan. It's going through all kind of consultation process, resident association, chambers of commerce and all that participating in it. But Penang, they said no need, just bypass everything because state director means he's part of the state planning committee. In fact, he's in charge of the state planning committee. He already put there, minutes already recorded, bypass. So it's wrong, completely wrong, what has been done and given approvals based on plan data. Oh, that's a good case. You give the right fees, I can answer the question. Yeah, I mean, it depends on a case by case basis because, can you rely on an illegal instruction, right, to justify? So it's an arguable point because as far as the civil servant MBPP is concerned, they say at that time this is what the direction was given, but direction was wrong. This reminds me of a very important international law case after Nazi Germany was defeated, right? Then at Nuremberg, this is called the Nuremberg trials. They brought a lot of people who were serving the Nazi. Hitler, of course, committed suicide, so he was not subject to any law, all right? But they established for the first time what they call the Nuremberg Tribunal. It's called Nuremberg Tribunal because it's set up in the town of Nuremberg. And they charge a lot of people a lot of senior people under the Nazi regime for carrying out extermination of Jews and so on and so forth. So one of the defense by Hans, one was a judge. He's a judge, right? It's in the movie, played by Burt Lancaster. He said, "This is, I'm a judge. Judge, I have to follow the law. This was a properly enacted law. You'll be surprised. Hitler didn't rule any which way he wanted. He went through the process of enacting decrees or rules. He followed the process. So the judge said, what do you want me to do? I followed the law. The case comes before me. I cannot decide on policy underlying the law. But the court said no. Finally, they said that you cannot enforce or you cannot carry out what later can be shown to be an illegal instruction, right? Because they had certain laws that, to exterminate Jews, bring them to gas chambers and so on and so forth. So can apply that sort of logic, you can still bring forth that kind of argument to say, if you are affected by it. But there are so many procedural problems that arise because you want to challenge something, but do it within a particular time frame and so on and so forth. So if this approval is given long ago, then all these kind of problems will arise. So no clear answer. And that's the way lawyers make money. Always don't give clear answers. So you have to come back to us.
I think this ties back to your answer as well as the gentleman's question. Because Penang, we have the Penang Structure Plan 2020 and the recent 2030 Structure Plan, which was gazetted not too long ago. So there, between 2020 and 2030, a lot of these submissions were made and approved at SPC level and subsequently by MBPP, especially in the rural area, where a lot of the kill land as well as agricultural land were converted and then and approved by SPC for high-rise housing. So the effects are there. Now, let's say subsequent to this judgment, we have a neighboring lot that challenges the submission. What would be the way forward?
Yeah, you see, this is where I said there are other procedural complications. First is because if a person applies under a law or under provision, which at that time seemed to be valid, right? Don't forget, in this case, the High Court, even the Court of Appeal ruled, that it's valid. Then, if a person acts on that basis, it's very difficult to hold him accountable. That's one. And then, if the rights, if whatever rights have been acted upon, then you cannot roll back that. There are some legal principles involved, like estoppel and so on. You don't have to go into that. You cannot then roll back because they did it in good faith, unless they are complicit. In our Taman Rimba Kiara, we showed that it was complicit because at that time, this pavilion guy, the very amching with the DBKL people, Tengku Adnan and all the fellows. And there was a lot of conflict of interest. They just simply went and, this was the, what do you call it, 26 acres of parkland, in the beginning of time, from those days when they took over from these, some colonial, what do you call it, companies and all that have been there. Then they just chop it into half, give the half, right? Joint venture with Pavilion, with the not Pavilion, with the Molten Group, and then change it to mixed development from park, just done by the State Expo. So the court said you can't do this kind of nonsense because you've not followed the process, because you have been complicit in it. So there's a question of complicit. So to answer your question, if it's a normal person applying and he has acted on that basis and he has been given permission to do it, all right, then it's difficult to roll it back. However, there is a qualifier to that in my view, right? And this is only my view, maybe right, maybe wrong. If there is no development as yet, or the person has not acted upon it as yet, then there may be a scope to challenge it. On the basis that now the law has made it very clear that all that process up to the point of the permission being granted was not adhered to, and therefore it's illegal. Because once a thing is illegal, there is also in law a dictum or a provision or a saying which says that once it's a nullity, you can even ignore it. You don't even have to follow it and challenge it, right? Because it's a nullity, which means it is void from the beginning. It never existed, in other words. So there is a basis there. If it has not been proceeded with to try to challenge, but that's left to be seen now whether it succeeds or not. Yes, this is a lawyer. So.
Good morning, Dato. Sorry. I have two questions. First one is slightly practical. Second one is the theoretical part. All right. The first practical part is I understand from the judgment that there was also a recognition of decisions that have to be given or reasons given by the OSC when bantahans are made by objectors. Now, for architects who are submitting people and lawyers who, let's say, we advise our clients who are KM applicants. Now, what happens if the OSC do not give a reason when they approve a plan or when they give approvals with conditions? Reading this Sunrise case, it can suggest that decision becomes irregular. Now, is that the case, or is that the thought process of the court that all bantahans reasons must be given by the OSC?
Yeah. Okay. Now, duty to give reason. Okay. This is actually the wider issue. You know, whenever we apply for anything, citizenship, I'm doing so many cases on, mothers have given birth to children overseas, married to foreigners. What happened to their children? You know? So we apply in all kind of situations, and the authorities will answer, just one liner only, sorry lah, tidak patuhi undang-undang, or something like that. That's it, full stop. Is there a duty to give reason? This has become a very important issue, which the federal court has, not only in this case, but in the other case, Taman Rimba Kera case, elaborated at length. Now, what is the position? The position normally is this: no need to give reason, unless the law says give reason. Okay, so no need to give reason. But the law has developed since that time, because last time everything acted in good faith, people accepted. Government is quite low key, doesn't interfere, not intrude so much into private affairs and so on. But the law has developed so much. Now everything can be approved by the government in the respect of everything that we can think of, right? So now they said, no, you have to look at the situation now, right? For example, in planning, right, you are allowed to, two things happen. You are allowed to object. So if in your vicinity, there is anyone who that you allege, like in this case, Sunrise, they allege certain things, right? Then they are given the right to object. Now, the right to object, they then give their objection. And then, as always happens in these planning cases, they said, yes, we have considered your objection, but proceed in any event to with the grant of the project planning committee. It means just CSA only, just a token. Court said no. In that case, for your objection to be seriously, for that principle of objection to be acknowledged in that law itself, all right, means that you must give reasons for your rejection or acceptance of the project. And to what extent you are going to consider that in the final planning approval. So the short answer is that because there is a process allowed under the law for objection, then it's only meaningful that the objection must be, reasons must be given if it's rejected or modified and so on. So now there's a very clear situation whereby in planning law, this is the first time in planning law that they have said you must give reason. Right? In normal cases, if you are affected directly, for example, there was a case where USM sacked or wanted to take disciplinary action against Rohana, Rohana Arifin, who was a lecturer. There they said, yes, you must give reasons. Because why? Because you are going to deal with someone else directly affecting his or her livelihood. Then if you're going to take some action, give them a chance to respond. There it was very clear. But this in terms of planning law is new. And also, the court went one step further beyond our argument. And they said that, look, if you don't give reason, right? How is the person concerned who is affected? How is he know whether to challenge or not to challenge? So he objected. He said, you cannot do it because this, because this, because this. And you just say, we have considered, and that's the end of the story, right? Now, how is the person going to, you must, in the name of democracy and fair play, you must give your reason so that person can decide, oh, okay, accepted, or not accepted, and decide to challenge. You see, what happens in these kind of cases, then when must you give your reason is also important. Because what happens is they will just give ditolak or telah diambil hatian and so on and so forth. Nothing more. Then when you challenge, then they come up with all kinds of reasons, no, because lawyers come into the picture and try to strengthen the case. I said no. We argued you must give at the time when the decision is made, not later on when you challenge. People may not even challenge because they don't know the reason and don't know whether there's a basis to challenge or not. So that's an important other provision that adds to the duty to give reasons. You must give it at that particular time when the decision is made, and not later when it's challenged and put in an affidavit and give all kinds of stories. Yeah, but you can challenge now, you see, under this authority, so you can give reasons. And then the other thing is, that's maybe leading on from that, is who can challenge, right? So they had argued, both in this case and in the Taman Rimba Kera case, they said only the people, because under the KL Act, KL Planning Law, objections can be made by people, I think, adjoining owners or something like that. All right. So they hear objections and then they proceed to give planning permission. They argued because then when we file the case, we file in the name of a large number of condominium owners, residents, association, and so on and so forth. Now they said only those who are covered by a rule which gives the right to make objection to certain categories of people, only those people can challenge. That's called Rule 5(3) of the planning rules. Planning rules is subsidiary legislation. We argued and the federal court accepted. Rubbish. Rule 5(3) is illegal because it is undermining that whole process, planning process under the main law. Because that planning rule is subsidiary law. You see, once there's a main law, to implement it, then the court enacts regulations or rules. All right, because this says you must apply. The main law says, okay, you must get approval from the local authority. But how do you get it and all? Usually planning, they put in the rules, they put in Form 1 or Form 3 or duplicate, and all that is done for the implementation process. So the court said, no, that Rule 5(3), if it restricts, is out. It's illegal. The Rule 5(3) is now ruled out. And who can bring a challenge? That's an important point, you see. Always the other side, and in this case, in these two cases, they argued very strongly. Who has local standard? Now, we argued that the law has developed to a state, where you should be given. If it's an illegality, for example, anyone can challenge. One person can challenge, 10 people can challenge. Anyone can challenge if you're saying that that is an unlawful activity. Because you cannot allow unlawful activity to go on, you see. And the court said, yes, we have to now look at what they call local standard, the standing to bring action. All right. We have to widen that category of persons who can bring this particular action itself. The only person who's ruled out, so anybody who feels is adversely affected. And if a law is bad, you are adversely affected because it can hit A, it can hit B, at any given time. So the only test is adversely affected. Are you adversely affected? And the test is very broad. They allow anyone to come in and let the court decide. And the court also said, therefore, reasons are very important to be given. Because then the court can see that at the time when you made the decision, whether or not you had a basis or no basis. Because later on, when you are challenged, of course, you give all kinds of talk and bull stories to try to justify because you're fighting already. And then you try to say, no, it's like this, it's like that, and so on. I did write a letter to explain, and then we have to say, no, we never received the letter. Then they said, yes, letter was sent, but the clerk in Governor and sending has resigned. All kind of stories come up. Court said, no, we need to know, and you give it at the time when the decision is made, because that's the most authentic and real reason. So the law has gone on even to on locus standi, has broadened the scope. Duty to give reasons is broadened the scope itself. Of course, a lot of authorities, they go on in their own way, because most of the time people don't challenge. So my friend is right there, that they don't give reasons. And then they wait for you to challenge them. And the sad part is, from my perspective, is if they are doing something that's obviously wrong, then they are not held. There's no no pain, They never get pinched at all, as they say, The too bad and all that doesn't happen. Why? See the police, for example, just to give an analogous situation. We do cases. They arrest you, okay? On the eve of one of the Bersih rallies, they arrested Maria Chin. She was the head of Bersih at that time. They arrested her, put her in SOSMA. SOSMA, not a big reason. The security law. They just put her there a few days and to try to suppress the Bersih rally so people be scared and all this sort of thing. And then a week later, after they released, then we challenge later to say there's no basis. There was no basis at all to arrest her. For security, there's no security issue at all that they established or could establish. All that they said is, because, they gave some future reason that he is probably going to give one speech like this and all that, which is speculative. But what happens in that kind of a case? Then we sue. So the police who are doing it, or whoever is the person directing them to be done, is not hit at all. They just give it to AG's chamber. AG chamber is removed. AG chamber is paid for by the government. They fight the case for you. You're not even really directly involved and made accountable. So a person who acts spatially on the face of it, act illegally, are never made really accountable in any way whatsoever. This is the sad part. So suddenly we get money. All right. So in Maria Chin's case, they finally settled and gave us some money. Who pays? Not the officer concerned, not AG's chamber. They take it from the public money. It's your money and my money, you see. That's why I'm very reluctant in some of these cases when we want to go for high damages. It's ridiculous because it's you and me paying, So there's no real accountability. But one of these days, we intend to bring a case where we want to make the person, if it's quite clear that he has acted unlawfully, to make him liable. Then when he has to pay, 400,000, 500,000 himself later on, before he accepts an order, which he knows, because they are all people who are civil servants who have been in who know very well all this going on. For example, in planning law, like my friend said, they're still not giving reasons, but there are now court cases already. And state not only they've got high officials who know and who are very competent. I mean, many of them, I'm not saying that they are incompetent and all, it's just that they, Aku Raja kind of a mentality, you see. But they know they're very intelligent and all, and they are also assisted by a large number of, legal officers. You've got state legal officer, got legal department. So they know. In fact, in this case, just to give you a story behind the story, right, is when when this case first came up, the appeal board, they went to the appeal board said planning permission was wrong. Then at that stage, actually, that the residents, and I was involved in that, made a representation to the chief minister at that time, the then chief minister. And the chief minister said, yes, we will, we will support you and all that. I don't know whether at the time elections are pending or not, but we support you and your residents are at our heart and our core of our efforts of our party and all that. But then when Sunway challenged the decision, they went to the High Court to challenge the appeal board decision. The state government, instead of siding with the people as they had said, forgot about the fact of their representation to the resident and engaged lawyers to fight the resident. And when the residents lost, asked for cost. 50,000 or something like that. So after that, the residents went back to the chief minister and whoever is responsible and say, what is this? You said you support us this and all that. The reason of the then chief minister, no, because sometimes these officers don't understand the miscommunication and this and that. And we will, actually let's look forward, forget about the past, and they no need to pay the 50,000 pounds. But after that, when we appeal, again, they engage lawyers to fight the resident, right up to the end. So you have duplicity in politicians, when they come to deal with people's affairs, right? Where they for their own reasons, they give certain, promises and all that. But it has a very serious impact in terms of the basis upon which governance is structured. Governance is at the will of the people. That's why when we talk, we always talk in the abstract. It's the government of the people, by the people, for the people, by the people, for the people. And these chief ministers and whoever else is now running for elections, right? They are there 9 to 5 to serve the people's cause. 9 to 5, completely, every department, so many departments on every aspect, right? So that is where the accountability becomes very important. And now courts, some panels of the courts are now responding to this kind of argument. So these two cases on planning law reflects the new ethos in courts, which are prepared to hold, to account to the federal constitution principle, to the broader ethos of governance, accountability, transparency. We look at the judgments, the two judgments, all this here, governance and transparency, accountability, all this now started all over the place. And that's why there must be adherence, and they will strike down in this case. You see, I'm sure it was a rude shock to these people here in SPC, the Penang State Government, as well as the Dewan Bandaraya Kuala Lumpur. Right? It was a rude shock to them that these processes can be rolled back by the court. They never expected it. For the Taman Rimba Kera, they engaged a large number of lawyers against us. We were one, right? And our team. But they engaged, the developer engaged a big set of lawyers, and the Dewan Bandaraya engaged a big set, and then the Yayasan, which was the CSR arm that had gone into joint venture with the developer, engaged a big set of lawyers. It went on for many days. So now they have to take the back seat, because now what's happening, Sunway has got what? Sunway has the large tract of land on hill slope land. I don't know what they're going to do with the hill slope land. So they cannot build on it, right? But I don't know what the next step will be. Same with the Taman Rimba Kera case, they've spent a lot of money to get that 13 acres. And then they already put up boards. They won in the High Court. After the High Court, they already put out flyers and all that, ready for taking all this and so on and so forth. So now they are holding on to land or permission, which means now, as far as the pavilion, the Molten guys are concerned, as far as we are concerned, what they have to do is, as part of their joint venture, they must develop the park into a better park and not put up condominiums, 72 stories, 50 stories, and so on. Same here in Sunway, as far as the hill slope land is concerned. They can't now build their large number of condominiums and bungalow structures and all.
The state is reviewing the local plan and will be already open for public participation. For example, theoretically, let's say this case, Sunway land, is not allowed to develop, and under the local plan participation, public actually view their points that it should be kept hill land or not be developed. And yet, if the local authority zone it for residential or development, regardless of the public opinion, what is the law or under the Town and Country Planning Act has for the public in this case, or for reversing it. Again, we have to take the state to court.
Well, you see, I think what will happen in that case is like this. All right. So the court has already ruled that you can't, and then there are some pronouncements that are made up that why you cannot. But then the state authorities now, which they are entitled to do, because now it's a new local plan, right? So long as it's consistent with the structure plan, right? They can then change it around, put mixed development further. So then the fact of the matter is, assuming that they can get the structure plan also consistent with that, then they have to give reasons as to in the process for developing this, they must give their reasons why they have incorporated this in the way that they have incorporated. Then you challenge the reason, because you are entitled to challenge the reason under principles of law. If the reason is irrational, if they have not taken into account relevant factors, material factors, and if it is illegal, of course. So illegal will be out because we are trying to make it legal. But if they do not take into account material consideration, for example, climate change, landslide, if your experts show that it will be vulnerable to this, that, and the other. So in short, the duty to give reason. B, then you can challenge if you find the reasons are not acceptable. If they say, oh, because we need housing for large number of people, so we have run out of land, and therefore no choice lah. We have to, like Hong Kong and all that. We have to use hill land, but then we make sure that the geotechnical report, the EIA reports, and all those reports, the technical reports are solid, so that there is no calamity. So then, exactly the point now, with regard to your reclamation of the islands or something, right? Exactly the point that will be made. They say, oh, we need land. And then the counter argument that I read from Penang Forum and all this, but we got a lot of land. That reason cannot fly. So that can be tested. Now, of course, what happened is NGO say, no, we've got a lot of land on the mainland. Why are you going to develop that? And we don't need this kind of land, affect fishermen and so on and so forth. But now it's the argument to and fro. And then your good, I don't know whether it's exco member or whatever, people like Zafrul and your beloved Chief Minister, I mean in a good way, but not really. All right. They come up and say, no, these are small group of people, always make noise and always be, and look at if we had gone by their noise, Penang would not have developed to this state and so on and so forth, right? Okay. But then when it comes to court, this is exactly what happened in this Taman Lembah Kera case and Sungai Arang case, case, right? A lot of toing and froing and saying, no, you're talking rubbish, no, we already got EIA, geotechnical. So, and they use this argument in court. But then ultimately, if you bring a case in court, they have to justify it. And so there is a basis. So it does two things, because it makes accountability very important. Okay, maybe they can justify and courts will agree. Then at least there has been accountability in the governance structure of this. That means government of the people, by the people, for the people. So of course somebody has to decide it, judicially decide it. Right? So let's people have to pay for the court cases.
So not accordingly to our opinion. So the only way to challenge that opinion is to bring the state to court.
Yes.
So people will have to pay.
Public, because if the public is concerned enough, they pay. Otherwise, how, man? But I mean, people. There are a group of lawyers like us, for example. A lot of it is done on a very minimal, sometimes pro bono basis, right? Pro bono means we don't charge and all that. But there are costs involved in bringing the case to court. And so you must be ready for it. I mean, you want to fight, you put on your uniform, combat uniform. You must be prepared to back it up. But nowadays it's quite easy, like you got crowdfunding and and then your chief minister last time, getting what 1 hour you raise with bond money of 1 million or 2 million. In fact, some people now can make money from this. They said, oh, this is a case, PJD link and all that, please contribute, right? All that they need is about maybe 100,000, and suddenly they collect 800,000. I don't know where the 700,000 goes to.
So let's ask just a question. If a project has been approved before the Sunway project judgment is out, can we, but let's say if it hasn't been built, or let's say maybe they built phase 1 and phase 2 still not built, can we apply the judgment retroactively to the project that has been approved earlier?
Yeah, well, general principle, you cannot apply something, a law, retrospectively. Because at the time when you did whatever you did, it was not wrong. So you cannot suddenly wake up one day and say, suddenly there's a law which says, all bald people, all bald people cannot enter, cannot go to this particular place after 8 o'clock and so on and so forth, right? So you cannot make it retrospective, generally speaking. But if it has not been acted upon, there is a basis for bringing in. Once it is acted upon, that means rights are vested already. In fact, that was part of the problem with the pipeline, because there were certain permissions already given before they talked about prohibiting absolutely hill slope development of that kind, right? So that is why they brought in the guidelines for special projects to preserve that. So that we never challenge. If it is already given, you've already acted upon it, you bought the land on that basis, then we cannot impose it. But if it is not acted upon, right, then there is some basis. You may not succeed, but there's some basis for, I think, for doing something about it. But yeah.
Say 5 years back, but this project was approved, let's say, last year. So this planning permission was declared null and void, isn't it?
Yeah.
What about his? His was approved later.
Yeah. You see, the point to remember about this case is that the planning process, if you do not follow the planning process, then anything that is as a result of that, right, is bad already. All right. So that is what is the law on the matter. So it is bad. So if it's bad, it can be challenged. But then there are defenses that the other person can put forward. The defense would be, for example, that that I already acted on that basis, I spent money on that basis, etc., right? So you cannot cancel it. So they will have some ground for that. But if it is, for example, in the Taman Rimba Kera case, there was already what happened in that Taman Rimba Kera case, we got DDKR, the public institution. Then they put forward Yayasan. They had Yayasan Foundation. The idea is Yayasan is supposed to carry out things for the interest of the people, the poor residents and all, because DDK has been part of the whole city, you see, the Yayasan. Then Yayasan, what they did is they went into a joint venture with this Mountain Group people. All right. Now, then they had a joint venture agreement already before we challenged. And that agreement, they had already paid out a lot of money. They had paid for the conversion of the land. The land was in the name of Yayasan because the government, right? So they took the land and entered into joint venture with Mountain Group, with the developer. And then but actually, basically, the developer is behind all this. The Yayasan got nothing. They're supposed to help poor people and all that. This taking away parkland is nothing to do with poor people. See? Although they said, oh, they're going to help some longhouse residents, because in one corner, longhouse residents on that. They say, oh, we are going to build, 8 blocks of 50 to 70 story condominium hall, and giving one small area to they say, oh, we actually doing it for that purpose. But that's another story now. But basically what it was they already had a joint venture. And Yayasan, the developer had already paid 60 million for conversion premium, because premium you will pay premium if you are professional architect, 60 million paid already. And then they had, of course, must have already incurred millions of dollars of cost. Official and unofficial. Right? So they stuck because they already, part of their argument was, look, we already gone on to this. We already, our machinery is already there, everything is there. How can now you roll back? But the court said no, because the whole thing was illegally done. Right? There were other issues involved, like conflict of interest, and so on, so forth. So there is scope depending upon the facts, particular facts of the case. Now, of course, we were told that the Morton Group want to claim from the government, right? Because they said now development, we can't proceed with it, so we must pay. So our advice is that you should not pay or cannot pay. In fact, if they pay, maybe we'll take them to court, because what happens really, people asking for, I don't know, 150 million or something, because they said the thing couldn't go on. But all along, they entered into a joint venture. So joint venture means I and you enter into a joint venture. Together we go. Then you are supporting you, DBKL people are supporting me all the while, or Yayasan people supporting me. Then even to right up to the federal court, you and I are saying, no, it's right, it's legal, and so on and so forth. So if I want to sue you later on, because I did not get the approval, it's not fair, because we went in it together. And you also, there's no breach. You have not breached anything. My agreement with you is not breached. It's the court that decided that it cannot be done. Nothing to do with you and me. So if you want to sue me, if you want to sue the government and ask for 150 million or whatever, you must show there's a breach. But there is no breach of this agreement that we have, which we entered into together with the commission. Okay. Yes.
Okay, that means the law can proceed on with whatever they want to do. But can the resident take injunction so that they don't proceed until you get a final decision by appeal court?
That's not injunction now. In all these cases, you see, like we are now challenging the KL city plan. KL city plan is local plan. KL got KL structure plan, and they got KL city plan. Right. So they had gone through the whole process to establish the local plan, etc., everything ready for approval, final approval in 2013. But they didn't implement it. They sat on it. All right. And then when the Pakatan Harapan government came in, Khalid Samad and all these solicitors in charge of Wilayah, they then were told to put in place like the KL city plan, because they've been sitting on it. Then they changed the KL city plan in various ways. Now Khalid Samad is a friend, but he went and advised, he changed and amended unilaterally without going through the process again. So first thing, you can't do that. That's what we're challenging. Secondly, in the interim period after that, between the time before the local plan is implemented, they allow a lot of developments to take place, including this Taman Rimba Kera, I think, without looking at the law properly. Right? And the Auditor General in his report to Parliament has said all these were illegal, or rather not illegal, but done outside of the proper structures, the local planning. So now we are challenging that. Now it's coming up before the court. Right? We are challenging that as well. So the short answer is, I forgot what your question is, but I think the short answer is that yes, you can challenge these kind of plans that they put forward. And when you challenge that, remember your question about injunction, right? When you challenge it by judicial review, there's a provision where you can apply for stay. It's called stay. Stay means tahan sampai keputusan muktamar lah, until the final decision is made, right? So it is very important because like we just did one last week where they are doing a project in Dinding lah. And Dinding is a good area for environment and all that. So a lot of KL residents are up in arms over it. So there, pending, we have got a judicial review. Judicial review is a two process. And of course, you get leave, then only you go. But when after getting leave, we say ask for stay. So court usually will give stay because otherwise they start developing the thing. Then end of the day, the whole thing is gone already, isn't it? Nasi becomes bubo and all that, and nothing to talk about. You know, to revert it back to the nasi.
Sorry, my second question. Thank you so much for all your answering it. But by the way, for the stay, we can apply in the appeals board as well for a stop work. In the appeals board, I think that's a procedure under our Penang appeal board's rule that you can. I think Yo Yang Po came up with that rules that allows an applicant or objector to apply for an injunction sort of stop work for works. Now, my second question is this, Dato. Back to your case. Now, with the plan DASA being declared basically null and void, as in the 1996 plan, if the council is today still referring to certain elements in that plan DASA, of course, not openly, not officially, such as like density or zoning or whatever, is that reference, is it an irrelevant consideration in your view? And is such reference wrong in law?
It is not only, it's illegal. Because the court already said plan DASA cannot be considered. It's an interim zoning implementation, which has no place in planning regulatory process. No place. So once it has no place, and you are going to rely on it, and you can show that the reliance is wrong in other ways, for other reasons, you know, because they say, oh, density, okay, but you can show why that density should not apply independently of plan DASA. And their justification is plan DASA, or you can show that the only justification they have is plan DASA, indirectly, you know, then that whole process will be declared bad because they have taken into consideration something that the court has already said cannot be taken into consideration. Because the law on the matter is such that if you want to challenge a decision, right, there are three grounds: irrationality, illegality, and proportionality. You see, all right, these are the three grounds. That's give you a bit of a after this, I think I'm going to advise people on the law also. Right. So illegality is very clear, it's illegal, right? So here would be illegal to look at that thing. Then irrationality means so irrational that it becomes ridiculous to allow it. For example, last time to prevent a birthday rally, the authorities came up and said nobody can wear yellow t-shirts with or without birthday, sign, nothing to do with birthday sign. You cannot have yellow t-shirt. Yeah, because it was identified with. Yeah, all right. So then they went to court, and the court said it's irrational. I mean, no brainer, you know. How can you say people cannot wear that? Whatever people are wearing yellow t-shirt for here, right? So that's irrational. But that's an extreme end of irrational. It can also be irrational if you take into account things that you should not take into account. All right. So it can happen in planning law that they take into account certain other factors like, in the long run, the traffic needs to be enhanced, and then start doing all kinds of irrational, not irrational, but irrelevant considerations, which you can show to be irrelevant for purposes of that particular project itself in that area under those circumstances. So that becomes irrelevant. But you can also have situations where it's not just irrelevant, but I'll come back to me. But the point, the fact of the matter is that there are various ways, various steps that you can use to challenge a particular decision itself. But you have to make out the case, really. You have to show why it is. So, like for example, they don't take into account certain considerations. Like now, very famous is climate change. Climate change becomes a very important consideration because it's a reality, I mean, climate change means extreme, that results in extreme weather conditions. So last time, like we are bringing a flooding case, the Taman Srinda and Shah Alam and Penang and all. Flooding came very fast, which never happened before. Of course, there has been flooding all the while. And therefore, when we bring up this case against the various, the National Disaster Management, Meteorological Department, so on and so forth, their defense is that, in fact, they are trying to strike out our case on the basis that this is act of God. Nothing to do with us, rain. But we are bringing in issues in relation to climate change to show that there will be enough warnings have been given throughout the world that there are extreme conditions, weather conditions. So you, as a national disaster management, meteorological or state planning and so on and so forth, have to take that into account. So if you're going to allow, you have gates, you have sluice gates to allow for water to flow out from flooded areas in Taman, for example, but those gates are inadequate for the conditions that now begin to prevail, the flooding, the extent of the flooding. You see the flooding there within a matter of minutes, suddenly the floods rose to about 10 feet, beyond human. There were people who, a lady who saw her parents who were in wheelchair in the ground floor, saw them drown because somebody could carry them up. Look, flood water rose very fast. So she viable, she can run up the staircase, but nobody could help because outside also is like that. So these are the kind of considerations that you can begin to raise, and it's up to the court to decide based on evidence that you can produce.
Plan TASA is not being referred to now, it's legal. So the state shall be using structure plan. And are they allowed to, or in your opinion, do you think it's legal for them to approve plans now, or?
Yeah, they can approve plans.
And if they reject the plans without giving the reasons that they follow the old density of the plan TASA and all that, that is the legal part of it.
Yeah, no, you see, they cannot rely on the plan TASA in the approval process. So that is the outline. What they can rely on are normal planning principles. I mean, you all are experts in that area, right? Normal planning principles, what to allow, what to not allow, what setback, all the other principles still apply. The other planning principles still apply. But structure plan and local plan, structure plan says to the use of the land, the zoning in relation to the use of the land. So if it is a park, then it is a park. Then if it's a cemetery, it's a cemetery, right? And so on and so forth. And then the local plan is supposed to provide the detail of the content. But without the local plan, they can still proceed because under your planning principle, somebody applies for his house to be demolished, and 2 houses to be made into one. There are planning principles involved, right? What you cannot do is justify your action by nothing more than the plan TASA. Because they said plan TASA says that allows that, so what was the problem? So this is what one of the arguments that was raised by Sunway was that, okay, look at these guidelines that have been changed, the special projects guideline. One of it says, yes, plan TASA housing, it is zoned as housing under the plan TASA. So they said housing under plan TASA. Okay, how can you object? So they were relying on the plan TASA as a basis to justify. I mean, one of the basics to justify the planning permission or guidance given based on the guidelines which relied on it. Yes. Yeah.
This is the court of federal court, isn't it?
Yeah.
So can it be a judicial review? Because I heard from some latest case from Najib case, it's gone to the federal court. And yet he decided to do a judicial review of his sentence.
Now we are entering the most exciting phase. Discussing Najib's case. Yeah. Okay, no, you see, it's like this, huh? Any decision made by a public authority, all right, by a local council or whoever, like some agency of the government, land office, all this. If you're unhappy with it, then you can ask that decision to be reviewed. So that's called judicial review, because go to the court to get it reviewed. So it depends, like in Najib's case, the review, the judicial review is that judicial review of a decision. All right. But a review of the case that Najib did, the final one that they did, is where federal court has already, like in this case, federal court has already decided, finish. It's called the apex court, the highest court. But after that, what do? Finish already, isn't it? But the court still allows, or the process still allows, the judicial process still allows you to review that decision. So final decision, finish. Then you review the decision. But it is very rare. It's not allowed. You have to file an application to say the federal court, although it's the final court, but I want to, review that. I want that another panel to review the decision because this decision. Okay. So there, it will not be allowed normally, because you must have finality in legislation. You already gone all the process, finished. Otherwise, you want review after that, another fellow on review, you go on forever, you see. So they will allow it in very rare circumstances. Right? In fact, I just did a case yesterday in the federal court where we said to allow only in very special circumstances, successfully resisted it. And the special circumstances are what? Supposing the court, the federal court, you and I are lawyers in the case, you and I argue, and then they go and decide the case on something not argued. You know what I mean? And then come up with a decision. Then not fair, is it? Then it's what they call breach of natural justice. Never happens, but if it happens, then that sort of situation. Or there is what they call quorum failure, because sometimes, the courts sit, 5 judges sit in the final court, make a decision, but before that, maybe 2 people resign. Can the 3 people come up with a decision? Or if 3 people resign or retire, can the 2 come up? Then there are questions whether or not it is a valid decision or not a valid decision. Or it is an obvious violation of the law. For example, the law already repealed. They said it's repealed already. The law is batal already. Then the federal court going to decide on the basis of the batal law, right? So very, very rare circumstances only you can really review it. So this is what Najib was trying to do. When everything failed already, then he wanted to be reviewed, the highest court's decision to be reviewed. That review is different. Although it's also done by the judiciary, that's not challenging a decision of a government agency or a government decision maker, but this is challenging the decision of the federal court itself. So then what will happen is they can, for example, in the Najib's case, so he said, the federal court was wrong, blah, 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 all that. Then if another panel will decide, if they agree that it is wrong, then they will send it back to another panel of the federal court to hear the matter all over again. But federal court is final, but they still must have a small residual power in case something obviously wrong. For example, they use a wrong law, Academic input. No. Supposing in that Najib's case, if he had succeeded in the review, he said the federal court decided, against him on this and this. Then he said federal court decision he wants to review. He goes for review. If the review court says, yeah, correct, it's not right and all that, then that case that was heard against Najib by the federal court will be more or less set aside, and they'll appoint another panel of the federal court to review to decide that case. Huh? Which one is you're on behalf of Najib or against?
Okay. Back to topic. Okay, I have a question. I'm just reading through some of the articles here on this Sungai project. I've spoken to some people in council itself, MBPP. And the short answer is there's a big impact. This case. From your point of view, what is that big impact in terms of how MBPP will operate from now on after this case has been ruled? Okay, thank you.
I think the way they have to operate is like I said that the federal court has actually set out where they were wrong. That's why I started my talk today by saying what they decided, how they decided, and how all the processes were messed up. Right. So now they have to revise their protocol or whatever they do now. But the most important thing is the local planning authority must maintain its autonomy. One of the basic problems I think that happens in a lot of local authorities, for some reason they are beholden to the state authority, SPC, and through that the state government, and they just follow. But actually, you see, there is you see the appointment of the mayor, the Dato Bandar, and all this, the councillors, is actually done by the governor under the local government act, not under town and country planning act. So they're actually very autonomous. The only problem, of course, is the system by which when you say governor appoints, governor doesn't know anybody, or he may know somebody, but he's the nominal head, like a ruler, right? So he has some discretion, but basically, where does he get his information as to who to appoint? Because the state authority and the state councillors and the state mayor knows that. I mean, that's the reality of the situation. So they are, I'm not saying that they bend towards the state planning committee, but that there is a suggestion, with which I may or may not agree, that they are beholden to the state company, to the state government, and therefore they are kamcheng with it, right? So that is the impression, that's the perception that exists. I was reading a book some time ago, I forget the contents, by this counselor called Dr. Lim Mahui. I don't know whether you've heard of him. Yeah, Lim Mahui. He's written a book in which he's pointed out all the situations in which it becomes very difficult for counselors to function properly, democratically, in accordance with governance principles of the proper governance. He talked about the practical reality, right? But the practical reality is what governs, because you want to discuss something and all that, and they said people already have got a viewpoint already. Then they say, okay, vote, money will be cut very long. Then the vote is taken, and people then skew their views in a particular direction. So the first fundamental thing is that the officers got to realize that they are autonomous, that they can defy the state authority if there is a direction that is given that is wrong. So one of the fundamental problems was that they just followed the direction. They said, follow guidelines done by state director. State director is not part of the local planning authority, isn't it? Right? Maybe wrong, but I think he's not. Yeah, right. He's not part of the local planning authority. So he has the state director goes and puts it forward. The state planning committee puts it in it, and the guidelines are wrong. This is what we've been telling them informally also. They're wrong. So once it's wrong, you don't follow. But they still follow. So they brought this calamity, the MBPP, they brought this calamity upon themselves without understanding the fact that they have an autonomous role to play. They have to recognize, they have to wake up to that power that they have and understand, because they have all the people that I know, or at least know about, they are all, they are not people who roll over easily and all that, there are people who are qualified, who know what is right, what is wrong, and so on. So they have to adhere to it. And if they do not know, then there are state legal advisors. They have access, and then the MDPP also sources out to counsel outside, lawyers outside, who can then also advise them. But they have to. So the basic thing is they have to begin to work from that fundamental basis. If they don't start from the basis, then it's going to be the same thing like my lawyer friend there says, they still don't give reasons. They still follow the old practice and all. SPC is under the Town and Country Planning Act, State Planning Committee. So actually, one of the points that is made in this case is the integration of federal and state. So they are saying that you have to have this before structure plan is finally approved. There is also input by the National Physical Planning Council. And that way they integrate and harmonize across the whole, because other than for federal territories, TCPA applies throughout the whole of the country. It's not just Penang, it's also the whole elsewhere. And it's one of the most democratic laws that have been enacted, because we follow the rules from those they found what, and slowly it's evolved. So it's very, very democratic. But because of the way in which the MB, the local planning authority, and the state planning committee, sees itself, they override all this. They write overshot. All right. So, for example, I'll give you a clear example how they. For example, they. The local planning authority shall not, must not grant planning permission. Now they introduced an amendment. Cannot grant planning permission for development in respect to which the permission is applied for would contravene paragraph 2AA. So they cannot give planning permission if it contravenes. All right. Paragraph 2A. Let's see what the paragraph 2AA that 2AA says. In dealing with an application for planning permission, the local planning authority shall take into consideration such matters as are, in its opinion, expedient or necessary for proper planning. And in particular, the AA is this, the directions given by the committee, if any, right? So this is what they said, you see. They said that we cannot give planning permission if it contravenes 2AA. 2AA says that if there's a direction given by the committee is SPC, State Planning Committee. So they said, yeah, this direction given. Yeah. In our case, right? In our case, they objecting or agreeing. Right. So they are saying the direction was given. State Planning Committee said use guidelines. A. B said no need to come back to us, and therefore no need to refer to MPPC. So this direction, they argued very strongly on this. But the position is Like if you look at section, there's another general section, right? It says that section 4. From time to time, give to any local planning authority directions not inconsistent with the provisions of this act. See? So you can give directions, but you cannot give any directions which violate the provisions of this act. And how can then you give directions, right, which violate the structure plan? Structure plan is under here. So they were giving guidelines, and it says that structure plan must be followed, and structure plan must go through the structure plan. You must make sure. Sorry, you say the structure plan. You have to follow the structure plan, and if you want to change anything in the structure plan, then you must go back to public participation and all that and amend the structure plan. But here, what they did is they bypassed the structure plan by issuing guidelines. So the guidelines, it is the structure plan said no hill slope development of this kind, none. Then you put guidelines say can, but subject to this and this. But you didn't go back to the structure plan. You're changing the structure plan. And this says if you want section 11 and so on, you're going to change the structure plan. You must go back because you've already consulted the people on a particular basis. Now you have to change the land use. You're going to change the land use, go back to people. You cannot just willy-nilly, let yourself decide, oh, the state planning committee decide. Cannot. So you can give direction, but direction must be consistent. And the court said it's inconsistent. There's no business doing it. So anyway, so the advice to MDPP is to come and see us.
Even FTC empowered to be the final decision body in planning, providing appeal and decision making process, and in final, unless there is irregularity or error in the process.
No, the actual final actually the authority that deals with planning control, right, under part 4 of the TCPA is actually the local planning authority. But their decision is referred to the SPC, so that it accords with policy or accords with whatever it is and all that. But actually the final decision-making body is still the local planning authority. But they are the ones who, under part 4, we look at part 4, the planning control. There are 2 headings, big headings. Part 3 says development plan. So this is where you do the structure plan, you do the local plan and so on. And then planning control is invested in the hands of the local planning authority. You see this says planning control part 4. No person shall use or permit to be used any land or building otherwise than in conformity to the local plan. Then no person other than a local authority shall commence, undertake or carry out any development unless planning permission has been given. And then the planning permission is given under section 22. Section 22 says of application. Yeah, so it says treatment of application as soon as possible after receiving application, blah, 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 and all that. The local planning authority shall decide on the application for planning permission. Right? And then in dealing with the planning permission, what must they take into account? And also, they cannot grant planning permission if it is contravenes the the provisions of any development plan. And development plan is defined as structure plan plus local plan. But if no local plan, then structure plan. So that's development plan. So ultimate authority is, of course, the local planning authority. Master plan, I don't know where master plan really comes in, because if you go by the planning law, the one that governs is the town and country planning. So master plan could well be a policy statement, depending on what it is, but it cannot override. That's the point that I'm making. It cannot override the provision of the law. And one of the good things about this decision is that it looked at all the relevant laws and integrated them and decided the case on the basis of what the whole planning law allows you to do or not allow you to do. So they looked at the National Land Code, because one of the grounds is I got a title. My title says commercial. So who the hell are you to stop me from doing commercial development? Right? You can't do that. On a sidebar, there was a case, you see, condominiums, you know. The in Sahil's case is one case where the people bought a whole floor in a condominium, and they want to do Airbnb. You know, so whether they can do it, because their argument is very simple. Airbnb is commercial. That title that they had is commercial. So why are you stopping me from doing commercial? You know, but there they said it is subject to planning control. It's subject to the rules like DBKL rule. And one of the DBKL rules talks about the right of what they call MC and GMB. You know what I'm talking about, right? The management council and all who run. And it gives them the power to regulate the use of the condominiums within that condominium project. So there they had put forward a rule which becomes a bylaw, which says that you cannot do that, cannot Airbnb. It's only for residential use or for normal rentals. So these people brought a case that went up to the Court of Appeal, decided by the Chief Justice. They said, yeah, none of your business, because, you know, commercial, I can do it. Airbnb is commercial. My title says commercial. So who are you to regulate or to limit what is already prescribed in the title itself? The court said, no, you can, depending on the law. So the same thing was raised in this case. We got grade A title. Grade A title is no limit. This is some relic. I think grade A title is some relic of land law in Penang. I'm not so sure. But that is the position, you know, that they said that is at the ground, and we look at the title. This is what we got. This is what we bought. So when Sunway bought that land, they bought the land on the basis of the fact that it's a grade A title which allows them, subject to some regulatory control, to use the land for the purpose for which they intended to use the land. So the thing about this case is it then looked at all the laws and integrated it with the whole planning law and said the conceptual basis. Look at my slides, which I have not looked at. Let's look at the earlier one. Yeah. That's not this one. Right? But you know, this basically deals with what I've been talking about. The comprehensive law and code. The next one. Okay, so all this. No, next one. No, sorry. Go back. So any application process you must look at the development plan, including subsequent amendments. So why? Because part of a democratic right to regulation and planning of land development. Right? This paragraph 204 is the paragraph in the Sunway case. The next one is no, next one. Okay. So here, this is a structure plan. Once it's developed, done with public participation. All right, this is what it is. The structure plan forms an environmental contract. So it's like a contract that has been formed, right, between these bodies, the planning authority, the local council, and the community. And this is what the court said. It embodies a promise by the council that objectives in plan adhere to in regulating private development and not allow any development that conflicts with the plan materially. And once gazetted, must adhere to its slavishly. Any amendment must go through the process. If wish to depart, justify for good reason. Mere policy with no statutory force, that's what they said, right? That the structure plan has no statutory force. So you see, it's like a contract that has been entered into. And you can depart, the second part. If you wish to depart, you can justify for good reason. For example, there's a need, they have a use of land, and just to give an example that comes to my mind, there is in Singapore, for example, right? They have changed their structure plan. I don't know what they call it there, but you know, a large part of some, or not large, but some parts of Singapore, they had huge cemeteries. But you know, the pressure for land was huge in Singapore. So they relocated, right? So you can depart, but you have a good reason for the departure, because you want to free up the land for your purpose. Same here for the justification being used for the island reclamation, you know, the island A or something like that. One of it is, I don't know whether it is or it is not used as a reason, but one of it I think is you know, usage of land pressure, usage of land, and so on and so forth, right? The interesting thing about that is it under, because this is in the sea, you know, so I don't know whose jurisdiction it is. Later you want to challenge it, whether it is under the local planning authority or not. Because it's somewhere out there, you know. So who's the body to sue, you know? You can see how the case shaping up in my mind already, isn't it? Yes. Sorry. Well, I mean, state Sunway can, of course, I don't know what Sunway can do. I think you can ask that anybody to do anything now, that they have to act within the law. And if the state wants to do it, they can do it. Or I don't know why the state will want to do it, because usually when you want to acquire land, you acquire it for a purpose. But to just acquire it for no purpose may not be in the best interest of the state, isn't it? No, land acquisition is done for particular, you know, there are grounds for acquiring land, right? You can acquire land for a public purpose, you know, you want to build an airport, you want to take roads or reduce traffic congestion and all that, you can acquire the land now. So it must serve the purpose for which it is being acquired, right? But if it is not for the purpose, you can even challenge the acquisition. People have challenged, for example, in Kuala Lumpur, Selangor area, they acquire the land, and then you are also entitled to acquire it for a private. There's an amendment to the act many years ago which allows you to acquire it for a private developer, right? So you can acquire land for Petronas, for example, right? Although it's not the state as such. Last time state only can acquire land. Land acquisition, not acquire land acquisition, take away people's land, give them due compensation. And then last time you could only do it for a public purpose. But then they added a clause because a lot of government agencies involved, not directly state authorities. So what Petronas is one of them, for example. You can acquire land for Petronas to set up whatever. But I don't know why they would want to acquire this particular land, because you do not have any at the moment, any projected development value now. But the government can justify it and do what they want if they want to. Yeah, you got something there. Oh. Yeah. Sorry, 1 second.
Morning, Dato. I just want to ask for maybe your views. At the state level, I mean, the issue of land, I think is still a sensitive issue between federal and states. At the state level, if you ask them, basically, land is state matter, development is state matter, which is our thing. Okay, and in fact, the law, most of the laws, I mean, even country and Town and Country Planning Act and all that, even our UBBN need to be ratified at the state level before it is applicable. Okay, so the issue here is that when the federal court decide that the state planning authority no longer has the authority, so to speak, to make decision or to advise the local council, I think there's going to be a big problem, because I think we still have a long way to go before we can get local plans done for the whole of Malaysia. And local authorities, especially we are looking at a small states. I'm coming from the East Coast. They don't have manpower, they don't have money, and things. It's a long way to go. They are relying heavily on the state planning authority to make decision or to advise them on developments. And at state level, the decision of the state planning authority has been used for expediency. Now, sometimes there are projects, there are new things coming which have never been foreseen before. New projects. Somebody wants to bring an industry to somewhere in Kuala Berang or things like that. So the local authority had to depend on the state planning authority. So if the decision of the state planning authority is now considered as, it's now, I think it's going to be a huge problem. What is your view on that?
Okay, I think that's an important point, because the point that is being made is that land is a state matter, and state matter means only the state, not the federal, can deal with it. So actually, the first point to note with regard to that question is that it's state against federal. So federal cannot campur tangan, you see, and direct the state to do whatever it wants or not want to do. But in the Town and Country Planning Act, everything is vested in the state, because it is the state and the state bodies and the state structures that are set up in respect of the state itself that make the decision. Because the local planning authority is a local planning authority in the context of the state. It's still part of the state decision-making process. So it's not the federal dictating and saying, oh, I want this to be done, you do this, you don't do this, right? That is why, for example, even the island reclamation is all state decision, right? But who in the state is vested with power to deal with the administration of that process in relation to giving permission, not giving, imposing condition, monitoring, the reporting, is a body within the state itself. So actually, it doesn't really raise the state or federal issue. All right, that's the first point. The second point is here we have the NPPC. So NPPC crosses boundary of the state because MPPC is chaired by the Prime Minister and Deputy Minister and Federal Ministry. So does it violate that principle? But the state has agreed to that. The states have agreed to the role of the NPPC in the planning process, in the planning control process. So again, it does not violate that particular state and federal. State and federal, you see, state is, as far as states are concerned, is very critical, and the point you make is very correct. So unless it is part of the state structure and within the state, or agreed to by the state, then federal cannot improve. That is why even the NPPC, they say it's advisory. They advise and say, okay, because at the end of the day, if some landslide calamity arises in a very big way, all right, then, the government is accountable, the federal government is also accountable, and so on and so forth. So they have certain integrative values to harmonize between federal and state, harmonize. That's why you see, for example, they have the National Land Code. National Land Code is to deal with, when you want to buy land, title to land, who is to be alienated land, what kind of land, and leases and all that. That's also actually a state matter, but they have a National Land Code to regulate it. So this is agreed to by states, all the states, that the National Land Code will prevail, but they set up a National Land Council. And the National Land Council comprises of state authorities as well as federal authorities. And they make all decisions in relation to, if, for example, they want to amend any provision of the National Land Code, so that they maintain still the harmony between federal and state. So the states can agree for harmonization. Forestry, for example, they don't agree. Forestry, we have a National Forest Act, which regulates use of forest. Now, forest is a very critical source of revenue for state government, because that's where you give concession for logging, and state makes a lot of money from that, all kinds of ways. So that one, they will never pass forestry. So every state has its own forestry act. Every state has its own forestry act. And even the Town and Country Planning Act, I think, if I'm not mistaken, the states also adopted into their legislation. So I think Penang was in 1983 or something. So the short answer, which I gave in the long way, right, is that yes, state bound, and this is in fact the planning control is under the state still, but within the state they can delineate. You see, within the state they can say, "Oh, EXCO decide this, and the state planning committee decide this, and then our other bodies decide this," and then you have to abide by that structure, and that structure gives it autonomy. So they have control. They can give directions and so on, right? But it is still within that structure. They cannot violate the structure. In this case, they violated that structure by giving directions which were wrong. They said you pass the whole Town and Country Planning Act, which you can't do. And you use something which is not in the Town and Country Planning Act, the plan data, which you can't do. So they have agreed that this is the law that binds you, but you cannot go outside of that law or act contrary to the law. Okay. What's it now? 11:30. Yeah. Maybe there are no other questions. Maybe I've heard, I'm sick of hearing myself. I don't know about you. Yeah. You see that the key documents that are relevant for purposes of planning law is the structure plan and the local plan. These are the key. So this is the message that is passed by this particular act itself. The rest all, unless they are accommodated within the framework of the Town and Country Planning Act, because as I showed in my earlier on, the structure, Town and Country Planning Act, TCPA, is A, comprehensive and complete. Here are the two features. Anything outside what this case teaches us is, anything outside of that, you can have regard. There's nothing wrong with having regard, because under planning control, if you see the provisions under planning control, you can have regard to so many things, right? Which includes policy of the state, right? Any plans that are put forward by the state, you can have regard to those in arriving at a decision. But you cannot use those, anything that is outside of the structure of the core structure of the Town and Country Planning Act to make a decision. You see, for example, you see, you can take into account in arriving at a decision, right? They say you can take into consideration such matters as are in the opinion, that means opinion of the local authority, expedient or necessary for proper planning. So this is the point that we always go on. Is it required for proper planning or not required for proper planning? So proper planning means you're the experts, right? Or the other experts who are involved in planning law. They are the experts, whether this is proper planning. And the thing also must be proportional, right? Proportionate to the objective. One of the other things that this has said is, whatever you do, it must be to further the purpose and objectives of planning law, as set out in this act. All right, that is the overall overriding when you interpret proper planning, purpose and objectives of the act. And it must always be proportional. Any act that is being done by any decision maker has to be proportional. Right? For example, if you park wrongly, you double park. Penang is so difficult to park, isn't it? So people just double park to get into a thing. I mean, then you can charge a person. But can you jail a person for a few minutes of parking to go and load or unload or something? So there's a principle of law which talks about proportionality. So a decision that is made must be proportionate to the purpose and objective. It cannot be disproportionate. You cannot, for some small thing, impose conditions which are so onerous that it is out of proportion now. You will say ridiculous. All right. So there are scopes, for example, when you treat an application, this is for application, you can take into account development proposal report, for example. So this can be by the state or by anybody else. But this is in the context of giving permission or not giving permission. But under the concept, under the development plan, which is the structure plan and the local plan, there is very wide scope for the authorities to advance policy proposals in accordance with, for example, they have a master transportation plan, all right, which is not countenanced directly, but then this can be introduced because development plans are about zoning for use of the land. The use is structure plan. Then how it is to be utilized in terms of concrete implementation in the local. So that's where then the question of the details come in now. The details will be in the local plan. They just take one, try and lepas, and it's going to be open. But the lesson to be learned from these two cases is that you have to be thorough. In the Town and Country Planning Act, right? You cannot do anything that is contrary. You cannot do anything contrary to the structure plan. And the structure plan must be followed slavishly, which means you must follow to the T. All right, once it is gazetted. But if you want to depart, you can, but you must give your reasons. And these reasons can be examined and objected to by the court, for example. Yeah, sorry.
TCPA Part 7, Section 37.
Yeah, okay, so this is also consistent now because this gives a remedy to a person who suddenly find because under the development plan, the structure plan and local plan or just structure plan finds that the land is zoned for a use which is contrary to what this title says. So, for example, we take the example, but don't forget all these development plans are future plans. So, for example, now the local plan is being discussed, isn't it? So now they want to suddenly have land use. So they don't have start saying, okay, this area used for this purpose, this area used for this purpose and all that. But you already got land, which now suddenly you have not done anything with the land. You find suddenly this land is, oh my God, that means I can't use it for the purpose for which I bought it. I wanted to build a factory or I wanted to do this. Now they say all auto used for auto parts and auto machines, and this one has to be put in, on Seberang Perai and all that. Then what do you do? So in that kind of a case, where you are denied beneficial use of your land because there has been put in place a development plan, or for any other reason, they say, there is a notice that is given, all right, for requisition. Then in that case, the land authority, all right, or the state authority can acquire the land. They can not just acquire the land, but you see, land acquisition is different. That's why they want to draw this purchase. So, not land acquisition is different. Land acquisition is okay. They want to build a road this way, right? So your land is there. They acquire the land. They give you compensation. Then there's a process for you to develop the quantum of your community. All right. But here, because it's under planning law, what happens if planning law makes land use deprive you of the beneficial use of the land? Then here, aside from the land acquisition, without they can give you a purchase, and then there's a whole procedure as to how can they do it for this case? I'm not so sure, because this is where a development plan then provides for this kind of a situation, right? And then you say, hey, I'm cut out because my land that I bought, now I can't use it for the purpose to which I intended, because the development plan has been already approved, which designates the use of this land for a completely different use purpose. And then the government can give you a purchase permit. And there's a whole process for that to be fair to the owner. But this is different from our case. You see, our case is, as far as they are concerned, now it is a court that has made a decision, right? Well, if the government wants, they can give a purchase notice, because they can say, especially for the Taman Rimba Kera, because it is tied up with the government itself, joint venture. So they can say, now, you know what do you want me to do? Now they are caught. Molten is developers who build Chakar Langit sort of condominiums and all, you see. To them, now that land is, what can they do? They can't do very much with the land. They've already paid premium for conversion, it's out. So they'll get their conversion money back from the land office. But they're stuck, right, for the rest of the payment that they have made. So the loss will lie where it falls. They have to bear the loss. All right. For here, they still own the land. There they don't own the land, you see, in Taman Rimba Kera. But here they own the land. So either they have to think of some use that is consistent with hill slope development, which I think they can't do. There's nothing. No, they didn't. But the point is there's this prohibition, you see. And if they want to depart, like I said, you can depart from a structure plan, use indicated in a structure plan. but you must have very good reason. That means you act contrary to it, lah. Because you are supposed to use it for a purpose, but you don't want to use it. You are saying that no need to use for that purpose. So that's where the problem, that you departing from the use of the word.
Zone as a zone.
Yeah. Yeah, I think for, you see, once you you challenge, you'll be challenging the state authority. isn't it? But state authority got a perfect defense. They said, look, we fought very hard to uh, to say that Plan Dasa is valid. But the court didn't agree with her. So you can't blame us. Lah. When you sue somebody, you are saying somebody has done you wrong. But they've not done you wrong. So two things can happen now. One is that you do it, sometimes you do an action because you think that you can come to some kind of a resolution. The one thing is that they can do it, and then they come out with defense, and then you all sit down together and say, okay, how do we resolve it? Right? So the state has got a lot of lands, I think, like, other than claiming from the sea and ocean and all that, you know. All right. But the point is that then they can work out some swap program lah, so that it's outside of that prohibited zone use under the structure plan or whatever. But it depends. So you can bring one action and then try to resolve it, or you can, without bringing the action, they can begin now a group of people who are affected by this Plan Dasa to begin to start negotiation with the government as a prelude to saying, otherwise, you see, look, we are suggesting this, otherwise we want to bring an action against you. And the government will have to give some kind of solution now there, because they themselves have represented two people that Plan Dasa is the plan that is operational. You know, that's the best I can do for the moment now. That's the best I can suggest without payment of fees. No, I'm just saying it. So I think okay lah. So thank you very much. It has been a pleasure interacting with you all. It's very active audience, small but very focused. And if anything, anytime, Pam. Oh, okay. So what do you call? I'll be happy to interact on these kind of issues. What I say is not necessarily the final position of law on the matter. This is my perspective of this particular case that I did. Of course, some of the comments I make may be biased in my favor because we won the case with me. So a bit of ego flotation there, you know. But given that, yeah, I've tried to be as neutral as possible to answer your questions. I hope it has been okay. Thank you very much indeed.